Hello and welcome back to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the Nachman Fawani Zimochek NPC Law Group, also known as VisaServe law firm with offices in New York, New Jersey. We also have an affiliated office in Canada and in Mumbai, India. So today I want to talk to you a little bit about what's called consular processing. And consular processing is an additional service that our office provides to individuals who are seeking to obtain a visa stamping at the U.S. consulate office abroad. So what many people have to understand is that while it's true that the U.S. Department of Homeland Security in the United States is responsible for the visa process, once that visa has been approved in the United States, it oftentimes then is sent abroad to the U.S. Consulate Office. That's under a different administrative agency. It's called the U.S. Department of State. The U.S. Department of State Bureau of Consular Affairs has offices outside the United States in various countries in which they administer the visa process. So it's called the Visa Office. And what individuals do, sometimes you can make an application directly to the U.S. Consulate abroad, and that's an online process in most countries, where what you do is you fill out a DS-160 form, and then you make an application for, let's say, a visitor's visa. So that's a consular processing procedure. But then oftentimes you have a process where you apply in the United States, or you do a petition in the United States. Once that petition is approved by the U.S. Department of Homeland Security, it then gets sent abroad to the U.S. Consular Office abroad, where the individuals can go and process for their visa stampings, which they then can use to enter the United States by showing it to a Customs and Border Protection officer who is also under the U.S. Department of Homeland Security, and then they will get a period of stay, which will be given in their passports. Usually it's a stamping now under the new electronic I-94 rules, and then you can go online and print out that I-94. So what I want to talk about again is I want to go back to the consular process, the consular procedure for you. And I want to talk a little bit about why cases might get held up at the U.S. consulate abroad. And we're familiar with these cases because this is oftentimes where our clients or potential clients would initiate a communication to our office and explain that their case may be under administrative processing. Now what happens is when an individual, after they filled out a DS-160 form, if they're not exempt from the interview, they might go to an interview at the U.S. consulate, and the U.S. consular officer will either grant the visa and stamp the visa in the passport and return the passport to the individual, or what they may do is they may not grant the visa, in which case they can either outright deny it, or what they can do is they can hold it for what we call administrative processing. Now, if you get denials may take several forms. Usually they are 214B denials. A 214B denial means that, let's say, you're processing for a non-immigrant visa and you don't have the appropriate demonstration of non-immigrant intent under Section 214B of the Immigration and Nationality Act. But another reason why a case may be denied, although it may not be an outright denial, is under 221G, in which case there may be a request for additional additional documentation that needs to be provided to the U.S. consulate. And what the U.S. consulate is supposed to do is to provide you in writing with an explanation of the reason why the case may be held. Now, oftentimes cases are held for other reasons. For example, there is something called the technical alert list. So if an individual who's making an application at the U.S. consulate abroad is subject to what's called the technical alert list, then the case may be held for determining whether or not that person's skill set is listed on what's called the technical alert list. Also, the U.S. Bureau of Consular Affairs has other types of reasons why administrative processing might occur. For example, there's something called a visa donkey, a visa mantis, or a visa eagle. And these require additional background security checks of the individual. So oftentimes we won't even know what the reason is as to why a case has been put under administrative processing. But that's something where we, as the immigration lawyers, can reach out through various channels that are available to us. And what we're able to do is try to ascertain for our clients and for their organizations, if an organization is petitioning, what the reasoning is behind this administrative processing. And of course, what we're also able to do is try to give the U.S. consular officer the appropriate information in a timely manner so that they can overcome these potential objections. So what we're going to do is, in the future, we'll have additional videos that drill down more on these other types of reasons why we might encounter resistance to having visas approved at the U.S. consulate offices abroad. But at this point in time, we just want to provide you with some general information as to why this might occur. If you, your friends, or your family may need any assistance with regard to consular processing or with regard to potential denials that you receive at the U.S. consulate offices abroad, please feel free to give us a call. Our telephone number is on the next slide. Thank you very much for your time, and we look forward to bringing you additional helpful information. Bye now.